In the Mahanoy case, the question before the Supreme Court was to what extent, if any, public schools may punish students on the basis of expression that takes place completely off school ground, completely outside of school hours, on a smartphone that belongs to a student. Brandy Levy sued her school district, the Mahanoy public school system in Pennsylvania, because it had suspended her for a year from the junior varsity cheerleader squad. Now, the reason why Brandy was suspended is because of a social media post that she distributed on Snapchat when she found out that although she had been accepted to the junior varsity, the JV cheerleader squad, she had not made the varsity cheerleader squad. So Brandy said, fuck cheer, fuck the school. She had one other F-bomb in there, fuck everything. That was objected to by school officials, and they decided to suspend Brandy from the junior varsity cheerleading squad because they saw this message as being indecent and inappropriate. Brandy asserted her First Amendment rights to express her own views about a subject that was not only deeply important to her, but also involved matters of public concern about the school, decisions that were made by the coaches of the cheerleading squad. She was doing it on her own free time, on her own phone, on her own social media app, to her own group of friends, at a place that was completely removed from school premises. The school district was making the same argument that the Des Moines School District made in the Tinker case, arguing that the expression at issue was causing a material and substantial disruption of the educational process. The outcome of the Mahanoy case was that the school's suspension of Brandy Levy was ruled to be unconstitutional, to violate her First Amendment free speech rights, because under the facts of this particular case, the court ruled that Brandy's off-campus expression did not satisfy Tinker's standard of a material and substantial disruption of the educational process or interfere with the rights of other students. That said, the majority took pains to reject the absolute categorical bright line rule that the intermediate appellate court had adopted, that all off-campus speech would never satisfy the Tinker standard simply because it took place off-campus. This was the first time since 1969 that the Supreme Court has upheld students' free speech rights, and the very first time ever that the Supreme Court has explicitly, directly protected free speech rights for students for expression that occurs off school premises, not during school time. The court stressed that allowing the school that power would deny students any free speech rights at all, and that is an intolerable outcome. Schools must continue to serve, as the court said, as nurseries of a democracy, teaching students that unpopular speech in particular must be protected.